Okay, Chapter 7 is going to be on state and federal real estate laws. Let's start out with the Civil Rights Act of 1866. That was created to make sure that there was not discrimination because of race. Now, in 1968, the Supreme Court had a special ruling to ensure the validity of that particular statute. That was the Jones versus Mayer, and what it basically said was, yes, the 1866 Civil Rights Act was in full force. In 1968 also, we got another Civil Rights Act that included the Fair Housing Act. Now, the Fair Housing Act dealt with residential real estate, and it also specifically dealt with professionals in the real estate profession or industry. So it kind of narrowed down the target to strictly real estate. And what it did, it expanded discrimination beyond race. It included race, color, religion, sex, national origin. In 1988, an amendment was attached to also include familia status, which are families with children, and also individuals that are handicapped. Now, let me also say that there are some exemptions from the Fair Housing Act. Once again, this only dealt in residential real estate, and it also deals with professionals in real estate. And the way they see it is that if you are a landlord and you own up to 3 units, this law does not apply to you. If you're a for sale by owner and you sell 1 home every 2 years, this law does not apply to you. But if you're a landlord and you own 4 units or more, you become a professional in the business. One of the things that the Civil Rights Act focuses on are how we're supposed to treat people. Steering has always been an issue. Steering is directing a person to or from an area because of discrimination. Blockbusting is where we induce a person to sell because of a discriminatory reason. And one of the things that the banking industry was doing is something called redlining, where they marked off areas of a community and said, we're not making loans in these communities or these areas because of discrimination. Those are all now illegal practices. And although the Fair Housing Act and the amendment in 1988 included handicapped individuals, 1990 we saw some other legislation that came in that was very specific ADA. In other words, the Americans with Disabilities Act came about in 1990, and it focused primarily on making sure handicapped individuals was able to have free access to public accommodations and commercial facilities. Some of the other laws that we need to take a look at that are going to be pertinent, especially to us in real estate, state law especially, is the Florida Real Estate Landlord and Tenant Act, specifically the Residential Landlord-Tenant Act. Now, let me tell you what's important about this. This law was created to make sure that there was a balance between landlords and tenants. Let's focus right now on who that landlord is. First, the landlord is not a broker. The landlord can handle escrow or deal with escrow accounts a little differently than brokers. Brokers, remember, have to place money in a trust account within a certain amount of time, and they can't commingle. They can't convert funds. Landlords, on the other hand, remember, are the owners, and they can handle their deposits just a little bit differently. A landlord can, like a broker, place deposits in either an interest-bearing separate account or a non-interest-bearing separate escrow account. But in addition, landlords can commingle funds. A landlord can actually commingle deposits collected in their personal savings and checking accounts. But let me tell you what has to happen when that does happen. If in fact the landlord commingles, they're going to owe their tenant 5% interest for the use of their money, plus they're going to have to post a surety bond with the clerk of courts in the amount of the deposit in the county that the property is located. This is in the event that that deposit is used and is not available for the tenant when the lease expires. Now, the disposition of the deposit has to be spelled out either in the lease, But the landlord, according to the Landlord-Tenant Act, has 30 days to deliver to the tenant some type of notice as to where that deposit is being held and all of the terms and conditions that I just spelled out for you. One other thing, if they put it in an interest-bearing account that is an escrow account, they're going to owe their tenant 5% interest, or at least 75% of what was actually collected. So there are a lot of rules and regulations on this Florida Landlord-Tenant Act that a lot of landlords don't know and a lot of tenants don't know. If a landlord intends to retain any of the deposit for damages, that landlord has to, first of all, send a certified letter to the tenant to the last known address by certified mail as to their intention, and they have to list every component of where that money is going to be spent. In other words, they have to get quotes from builders or whoever's going to be doing the repairs. That has to be done within 30 days of termination of the lease. If they fail to send that notice to the tenant within 30 days by certified mail, they give up any right to any portion of that deposit. The Uniform Land Sale Practice Act is simply a law that says that if a developer is selling lots to individuals, that there's a certain disclosure that has to be made. Now, the size of the lots have to be at least 50 lots or more in that subdivision. And there's a public offering statement that has to be delivered to each and every buyer. And what that does, it lets them know what they're buying and gives them a 7-day rescission period to withdraw from that contract. Now, this law does not apply if a subdivider is selling to builders. It only applies when subdividers are selling to the general public. Lotteries are also something that we need to be aware of. The state of Florida says that we are not allowed to do lotteries in real estate. And all a lottery is that when we induce a person to purchase something in hopes of winning something, that's construed or considered to be a lottery. Those are illegal for us. And that's all I have in Chapter 7, the state and federal real estate license laws. So why don't we now turn to our review, and let me give you what we have there. Chapter 7 reviews state and federal real estate laws. The 1866 Civil Rights Act prohibits discrimination because of race, regardless, and currently it's in full effect. The 1968 Fair Housing Act prohibits discrimination based on race, color, religion, sex, national origin, familial status, and handicap as it relates to a residential transaction, but remember this only applies to real estate professionals in the business. Jones versus Mayer confirmed the validity of the 1866 Civil Rights Law. Steering is directing a person to or from an area. Blockbusting is inducing a person to sell because of discrimination. The Florida Residential Landlord-Tenant Act allows landlords to commingle deposits with personal funds. If they do that, they're going to owe their tenant 5% interest for the use of their money. Plus, they have to post a surety bond with the clerk of courts in the amount of the deposit. All a surety bond is an insurance policy. The Uniform Land Sale Practice Act requires subdividers who are selling 50 lots or more to provide a buyer with a public offering statement giving a 7-day rescission to change their mind in the contract. And that's all I've got for Chapter 7's review.